Greetings, ladies and gentlemen. My name is Tshepiso and I'm a candidate attorney at PPM Attorneys, and I'll be briefly discussing the South African e-commerce regulatory landscape and the recent developments. Electronic commerce refers to the trading of goods and services over the internet. Over the past year, South Africa has seen a significant rise in e-commerce. Electronic commerce refers to the trading of goods and services over the internet. Over the past year, South Africa has seen a significant rise in e-commerce. According to a study conducted by Worldwide Works on online retail in South Africa, it revealed that South Africa has passed the 50 billion rand growth milestone in 2022. In 2023, South Africa is expected to see an even bigger growth in e-commerce as small and medium enterprises and big international companies enter the e-commerce market. In this video, I aim to provide a high-level overview of South Africa's key laws that apply to electronic commerce. The primary piece of legislation that deals with e-commerce regulation in South Africa is the Electronic Communications and Transactions Act 25 of 2002. The purpose of the Act is to facilitate and regulate electronic communications and transactions. It addresses, amongst other things, legal requirements of and communication of data messages, as well as consumer protection in electronic transactions. ACTA covers areas including the information that suppliers must make available to consumers on the website, performance, and cooling off periods. The next act is the Protection of Personal Information Act 4 of 2013, which is South Africa's data protection legislation. The purpose of POPIA is to, amongst other things, safeguard personal information when it is being processed by service providers. In the context of e-commerce, POPIA is applicable in respect of payments for and direct marketing of goods and services by suppliers. To make payments, consumers may need to share their personal information, and the supplier is required to process the personal information in accordance with POPIA. Consumers are also given certain rights regarding direct marketing of goods and services by means of unsolicited electronic communications. The next act is the Cybercrimes Act 19 of 2020, which came into operation in December 2021. The purpose of the Cybercrimes Act is to create offenses such as cyber fraud, forgery, and extortion. In the context of e-commerce, the Cybercrimes Act protects consumers from fraud, forgery, and extortion in e-commerce transactions and establishes offenses in relation to e-commerce transactions. Lastly, we have the Consumer Protection Act 68 of 2008, which also applies to electronic transactions. The purpose of the CPA is to promote a fair, accessible, and sustainable marketplace for consumer products and services. Among other things, it addresses the cooling off periods, which gives consumers the right to cancel a transaction within a specified time where the transaction results from direct marketing. It is also worth noting that in the context of e-commerce, certain provisions of the CPA do not apply to transactions where certain provisions of ACTA apply. For example, the provision on cooling off period in the CPA states that the provision does not apply to a transaction where the cooling off period provision in ACTA applies. Another noteworthy development that might change the e-commerce regulatory landscape is the Online Intermediation Platforms Market Inquiry that was launched by the Competition Commission in 2021. The inquiry was initiated because the Commission had reasons to believe that there exist market features within online platforms which impede, distort, or restrict competition. In the context of e-commerce, the inquiry was limited to digital platforms that facilitate transactions between business users and consumers. The Commission released the inquiry provisional report in July 2022. The provisional report chapter on e-commerce can be accessed from the Competition Commission website. The final inquiry report will be released in February 2023. SMEs and big tech looking to enter the South African e-commerce space need to ensure that their business practices are aligned with current e-commerce regulatory landscape. This will enable them to continuously grow and thrive and ultimately promote healthy competition in online markets. For more information on recent developments in the ICT law space, you can follow us on our social media pages. Thank you for listening.